Good afternoon and welcome to Law and Crime. I'm Angelica Spanos. Thanks for joining us this afternoon. Okay, so the production company doesn't have to turn over this extra footage, and the handwriting expert is allowed to testify, but can only give and refer information that's based on experience, not scientific facts. So that is what came out of this hearing yesterday. This is new information from the hearing out of California. With me today, Silva, Megerditchian here to break this down, criminal defense attorney. Silva, here in the studio, I've been talking about this with Chad, and he thinks that this footage and this video should have been able to be used. Do you agree with that?
Hi, Angelica. Good morning, or I should say good afternoon. I absolutely agree with Chad, Angelica. It's the best thing that defense argued, and I know that Chad brought this up too, is that the prosecution must turn over materials that are unedited in normal trial purposes. We don't allow, handwritten notes or redactions in trial. We expect to get all of the evidence clearly. In this case, turn it over. The judge kept on saying it's overbroad. No, I think the most essential thing in this case is getting all the information, because the most important aspect is it's Robert Durst's own words. We should see, the jury should see everything surrounding those words, because the words themselves are so hurtful and essentially are an admission. So I think the judge got it wrong.
All right, Silva, thank you. And Chad, one of the other things that we talked about is this handwriting expert. So this handwriting expert can testify, but is going to have to say things like, based on my experience, or this is my opinion, not going to be able to use fact or scientific certainty here. Is that strange? I mean, that is going to be something that the defense now can attack.
It is a little bit strange with me, because you have to qualify an expert before they testify. So it's a little unusual that an expert is going to be qualified as an expert, but then may not be able to render an expert opinion. That's sort of the whole reason you have an expert testify in a trial. As I said before, it's going to be very fertile ground for the defense to cross-examine this expert on.
Right. All right, Chad, Silva, thank you. We know about this witness that is expected to testify named Doug Oliver, and this is one of Robert Durst's friends. And we are expecting to see him testify, and he will likely be a big witness here. But yesterday in this hearing, the attorneys were arguing and going at each other about this. Let's play you this clip. All right, so we're introduced now to Doug Oliver, who is in the courtroom. He's there because he wasn't cooperating with the prosecution at any point, and he was ordered to be in this room because he wouldn't give them their phone numbers, wouldn't speak to them over the phone. So that's why he's there. He's a longtime friend of Durst. Clearly, seemingly not exactly easy to work with, as he has been saying that if he's going to have to come to these hearings and this trial, he wants them to pay for the fuel for his private jet. He will not fly commercial. Interesting character here. Silva, what do you think about this guy?
I mean, it's Hollywood, isn't it? I mean, so here's the issue. He should not have been in court. I mean, I love how, Chad and I are kind of arguing off camera, just saying, why is he in court? He should be outside. I mean, if they're so worried that he's going to walk away, have a deputy stay out there, have him monitored. But he should not be in court listening to these arguments back and forth. I mean, he's not cooperating, but there are ways that you can also protect counsel, their arguments, and really protect Robert Durst. That's his constitutional right. So it's hysterical. And to say it more that it's Los Angeles, I mean, the fact of the matter is saying, well, I have a private plane, I'm going to be in all of these places. Look, you're under a court order. You need to be there. And if you're not there, there are going to be consequences. So this back and forth is quite hysterical to watch.
All right, Silva, thank you. Chad, do you agree with that? And you mentioned that this might be grounds for appeal later on.
Absolutely. They should have their appellate counsel there in the courtroom taking notes. I mean, from the bad rulings on the motions, which I think is an appeal issue, for allowing a witness to remain in the courtroom prior to his testimony to hear all the arguments. I mean, this case is definitely got some appellate issues going forward. The reason you don't want a witness in the courtroom listening to all the arguments prior to testimony is because even if subconsciously, maybe consciously or subconsciously, they then know how to tailor their answers in light of the arguments that they've already heard while sitting in the courtroom. If you need him to be present because he's been uncooperative, fine. Order him to court, but have him sit out in the hall like every other witness does prior to their testimony.
Right, just like Silva said. All right, Silva, Chad, thank you so much. We're going to take a break right now. When we come back, we'll continue to break down this hearing and plenty more. Stay with us.